not in possession of simply by virtue of having these two contradictory documents, which are Exhibit D, which are attached to Exhibit D, which are attached to Exhibit D. And, my lords, it was explicit in the testimony that was provided by the second petitioner's witness that the agents of the candidate, the petitioner, had issues with some of these collation sheets and began to air them in the discussions to the relevant officials of the EC, and we're awaiting appropriate responses. Now, my lords, as I've said, Exhibit C was also cross-examined upon extensively, and a lot of arithmetic calculations were made in respect of Exhibit C. With different permutations of numbers. And we are saying respectfully that what all that proves is that without knowing the authentic, original documents on the basis of which the chairperson of the first respondent undertook her solemn constitutional responsibility, we are all in the dark. Is there? My lords, we are conscious of the fact that in the election petition in 2012-2013 election, and the ruling of the court, which is found in 2013 Supreme Court of Ghana Law Reports at page, the special edition, at page 61 onwards. The ruling of the court states clearly why their lordships on that occasion did not grant the application. And I would respectfully refer to a passage at page 71 of the judgment of the ruling read by Her Ladyship Sophia Adinura. And she says as follows: in the circumstances, we hold that the petitioners are sufficiently and well informed about the election results, which had enabled them to mount this petition on grounds of malpractices in 4,709 polling stations, based on the contents of these duplicate documents in their possession. In that case, the petitioners mounted the petition on the grounds of 24 categories, as they put it, of malpractice, In initially 4,709 polling stations, it became 11,000 by virtue of subsequent amendments, 11,000 and more. And so what the court was there saying is that the petitioners themselves have already put forward, in support of their case, documents that they had confidence in. They had put them forward. And therefore, to ask to inspect documents when you yourself have said, we are putting these forward and this is the basis of our case, that is contradictory. In this petition, my lords, we have not put forward results or malpractices in 4,709 polling stations. In this petition, we have put forward the words of the declaration of the chairperson, the returning officer, the only constitutionally mandated body, or person, I should say, not even body, the only constitutionally mandated person to exercise that responsibility. And so clearly, the rationale, the ratio decidendi of that case cannot relate to what we are dealing with in this petition. And her ladyship goes on to say that the affidavit in support of the application does not disclose any need for the inspection and making photocopies of the originals of the documents. My lords, nobody can say that in this case we are not disclosing any need for the inspection in a situation where we have changing numbers, and in a situation where to this day we are in no place to state a definitive number. In those circumstances, in our respectful submission, it is actually even in the interest of the first respondent, in terms of transparency, in terms of fairness, it is actually in their interest to make available. That is why, frankly, we did not expect that we would have to make this application before that request is granted. We honestly thought that this was something that would be resolved and we would go and have the opportunity to inspect. There are clear provisions in the rules of court within a reasonable time and within reasonable circumstances, and we cannot obviously flout those circumstances. So this is something that could have been resolved, in a very straightforward manner by enabling that inspection to take place without having recourse to orders of the court. But we have not had even the courtesy of an acknowledgement of our request, and therefore we are obliged to seek the orders of the court in order that we can achieve what will enable us to have a fair hearing of the petition that we brought to this court. Now, my lord, if there's nothing to hide in terms of transparency around these originals, it's difficult to appreciate why an inspection could not have been granted in the course of the last 14 days or so since we filed. 19, 12 days to the end of January, so about 15 days. If there is nothing to hide, I mean, if the interest of the first respondent is transparency, as has been indicated, then why would it be so difficult? Why would it be so difficult to allow access to the originals. We haven't come relying on our duplicates saying that they are the basis of our case. We've come relying on her own declaration. Her own declaration speaks for itself. So, my lords, in this situation, we require access to the originals, which we can then compare with what we have and try to get to the bottom of these ever-changing numbers. Now, my lords, the reference that I made to a fair hearing, my lord, is also anchored because we are saying effectively that this access to these documents is required for a fair hearing in this case, because it is not within the province of the first respondent just to pick and choose numbers from different sheets in the way they sought to do in cross-examining on Exhibit D. It's not within their province just to pick and choose and say, oh, this document which you have, it didn't include Ayenswanu. There's nothing on the face of the document which says Ayenswanu is there or not there. Nothing. And this one which you also have, which is supposedly about the same regional results, regional collation, that document has different numbers. And we just have to take it from them that Ayenswanu's 40,000 is what has led to the difference. Well, that is totally unacceptable, with the greatest respect. And Article 19(13) of the Constitution makes it clear that this court is required to give a fair hearing within a reasonable time. May I just, with your permission, read that article? An adjudicating authority for the determination of the existence or extent of a civil right or obligation shall, subject to the provisions of this Constitution, be established by law and shall be independent and impartial. And where proceedings for determination are instituted by a person before such an adjudicating authority, the case shall be given a fair hearing within a reasonable time. Now, my lords, as I indicated, we are asking for a fair hearing of the petition that we have brought. And for that fair hearing, we are submitting that the matters that we have, the documents that we have sought access to are necessary documents in order to understand the case that is being put against us, with all its changes and permutations. And so it's our respectful submission. And my lords, I may just make a comment finally on 6. The request in 6, that is not dealing with originals, that is dealing with records of the alleged update to the purported declaration. Now, my lords will observe that that update, Exhibit B to PW1's witness statement, that update is not signed by anybody. It's a press release, and we do know. Oh, okay. Okay. that update is not signed by the chairperson. It is not signed by anybody. And we do know, my lords, that the constitutional role that is assigned to the chairperson, both under the Constitution and under CI 127, that role cannot be delegated either to a media relations officer or to a deputy or any other person. It cannot simply be delegated. And therefore, how the records relating to that alleged update are things that need to be inspected, particularly when we have pointed out to your lordships that in that update itself, certain figures are put there which are different from what we all heard in the declaration. So some records are required, and no doubt there must be some basis internally for the alleged update, and that's the essence of what is in paragraph 6 as distinct from paragraphs 1 to 5. It's our respectful submission, therefore, that in the interests of justice, this application be granted. And I would also just conclude with what is provided in Order 1, Rule 2 of CI 47, that these rules shall be interpreted and applied so as to achieve speedy and effective justice, avoid delays and unnecessary expense, and ensure that as far as possible, all matters in dispute between the parties may be completely, effectively, and finally determined, and multiplicity of proceedings concerning any matters avoided. Indeed, this proceeding, in our view, is really quite unnecessary because it could have been dealt with expeditiously. My lords, I omitted one point in their response that I just want to comment on in one sentence. Both responses begin to raise issues about burden of proof in the case and so on. In our respectful submission, issues of burden of proof are irrelevant to the inspection of documents. The burden of proof in this matter is something on which no doubt we'll have occasion to address on different aspects. Whether the burden of proof is on us to do this or that, those are matters that at the appropriate time we'll deal with. But in their affidavits, essentially, they are laying claim to some view of burden of proof, which is legally very suspect, but on that basis, they are saying that this application should not be granted, and we feel there is absolutely no basis for that.
You refer us to Order 9, Rule 1. Can we take a look at you refer to Order 21, Rule 9. Can we look at Order 21, Rule 11, and if you may address us on it? Since I believe the primary objective of this application is to determine the total valid votes cast. That's the primary objective. Your application, yes, is to determine the total valid votes. No.
We cannot be limited to just the total valid votes. I'm sorry. Yeah. My lords, this application is not just the determination of the total valid votes cast, because the total valid votes cast goes back to whatever was happening at the regional collation, that is the Form 12 that is referred to, and about which there's been evidence that there was some dispute about that. So it is not just the total, it's also to do with the allocation of the votes. Your lordship will see that in the Exhibit D attachment that we have, there are differences in the allocations of the votes cast. So it cannot just be in respect of total valid votes cast. It cannot just be.
Can you look at Rule 11? Rule 11, sub-Rule 1.
Order 21,
Rule 11.
Rule 11. Production to be ordered only if necessary. Yes, my lord. An order for the production of any document for inspection or to the court shall not be made under any of these rules unless the court is of opinion that the order is necessary either to dispose fairly of the cause or matter or to save costs. And then 2, where on an application under this order for production of a document for inspection or to the court, privilege from the production is claimed or objection is made to the production on any other ground, the court may inspect the document to decide whether the claim or objection is justified. Attachment to Exhibit D. In our respectful submission, shows the necessity for knowing what is the original document on the basis of which we must choose one or the other. What is the original document? That is my submission.
I have a question. When you go to inspect them, what will you be doing?
Well, we'll be comparing them with documents that we have, which we regard as authentic, to see whether indeed they are the same. That's what we'll be doing.
But you don't see the need to tell us what you have as your valid vote?
No, we do not have the need because we are not the returning officer, with the greatest respect. We are not the returning officer. And my lords, with the greatest respect, this is quite an important point because His Lordship Justice Apau did ask certain questions in relation to PW1, and in our respectful submission, those questions are completely irrelevant to the issues that have to be dealt with, because